Although secondary activity directed against neutral employers is mostly unlawful, secondary activity isn't the only way for a union to try to gain leverage against an employer with which the union has a dispute. Sometimes a union will engage in picketing and handbilling directed at consumers to put additional pressure on a primary employer. Consumer picketing is lawful, but subject to some restrictions. Suppose a union was on strike against a group of fruit wholesalers because the wholesalers sold apples from non-union growers. In support of the strike, the union picketed local supermarkets that purchased apples from the wholesalers. The picketers carried signs stating that the supermarkets sold non-union apples and asking consumers not to buy those apples. The union picketed only during regular business hours at consumer entrances. Was this picketing lawful? Yes. The picketing was lawful, even though the supermarkets were neutral third parties in the dispute between the union and the wholesalers. In the Tree Fruits case, the Supreme Court held that a union may lawfully picket a neutral retailer if the picketing is limited to times and places when consumers are or may be present, the picketing occurs only at consumer entrances, the picketing targets consumers and not the retailer's employees or service providers, and the picketing's message is limited to discouraging consumers from buying the picketed product, as opposed to encouraging consumers to boycott the entire neutral retailer. The key question in determining whether consumer picketing is lawful is whether the picketing threatens, coerces, or restrains either the consumers or the picketed retailers. The answer to this question sometimes turns on whether the picketed business depends on the disputed product for its economic survival.